Jonathan Pollard, non-compete and trade secret lawyer in downtown Fort Lauderdale, Florida, and I'm going to talk today about responding to cease and desist letters. As some folks know, we do a great deal of non-compete and trade secrets work. More than 70% of our practice involves non-compete litigation, analysis, and dispute resolution. I personally have been interviewed by numerous publications, media outfits, etc. about non-compete and trade secret issues, including the BBC, reporters from Inc. magazine, the Tampa Bay Times, the National Federation of Independent Businesses. I've had articles published on law.com and on Law 360 all about non-compete and trade secret litigation. I write a blog which has approximately 500 subscribers. It's called the Non-Compete blog. It covers recent non-compete and trade secret cases. One of the reasons why I'm so interested in this particular area of law is because I think it's very important. I have very significant philosophical and moral issues with how non-compete agreements are being used in today's market. In my view, non-compete agreements are being dramatically overused, misused, and abused. And I think there are some real issues there in terms of inequity, unfairness. So I have big-time philosophical objections to the way non-compete agreements are being used throughout the country, and particularly in the state of Florida, which is probably the most pro-non-compete state in the entire country. And that's right, Florida enforces non-compete agreements more aggressively than any other state in the country. And I know this because I take a comparative view on non-compete agreements, non-compete law, non-compete litigation, meaning, I take a wide view from state to state throughout the entire country on a weekly basis, reading new non-compete cases, reading new decisions, reading about developments, in state law, changes to non-compete statutes, etc. So from my perspective, Florida is by far the most aggressively pro-non-compete state in the country. So that's why I do this. I think it's very important. I think it's socially relevant. I think it's important. And I think it has a very real impact on people's lives. So that's why I do this. That's why I like the work I do. That's why I take it so seriously. This matters to me. So let's talk about responding to cease and desist letters. Usually you have one of the following three scenarios. You have an employee who worked at a company, left, and is now working for a competitor. You have an employee who worked at a company, left, started her own business. You have a person who owned a company, sold the company, and is now looking to get back in. In all of these instances, the person has a non-compete agreement. In every non-compete dispute, maybe not every, but the vast majority of them, the first shot fired is a cease and desist letter. The company sends a letter that says, you worked here, you left, you're working for a competitor, you sold us your company, you're getting back in, you have a non-compete agreement, you're violating it by doing X, Y, Z. If you don't stop immediately, we're going to sue you, we're going to seek an injunction, and govern yourself accordingly. And for some reason, I find the phrase govern yourself accordingly absolutely hilarious. It's ridiculous in my view. I would never use that phrase in a letter, but apparently every lawyer in the state of Florida uses the phrase govern yourself accordingly, and I think it's intended to be sort of vaguely stern and intimidating. It just makes me laugh, but that's just me. So you get the cease and desist letter. This is the point at which I come in. In any given week, I get 20 or 30 phone calls from folks who have just received a cease and desist letter, and they always want to know what their options are. You have three basic options. Option one, do nothing. Option two, hire an attorney to send a response. Option three, sue them first. Now, let's get into each one of these options in a bit more detail. Option 1, you can do nothing. If you get a cease and desist letter, you always have the option to simply stick it in the drawer, ignore it, forget about it, and see what happens. I think that's a terrible idea. From my experience, when people do this, they usually wind up getting sued. In fact, a gentleman called me a couple weeks ago, had a cease and desist letter. I told him what his options were, and quite frankly, I don't have, hours to talk with people on these sorts of things if they don't want to retain us and they don't want to get something done. If they retain us, if they hire us, then absolutely, we will do the work for them, we'll take care of them. They're our clients, that's what we do. But, a lot of times folks will want to call and they want to talk to me, my colleagues, and ask a bunch of questions, this and that, when I've already told them, look, you can do one of these 3 options. Do nothing, send a response, or sue first. That's it. And he decided ultimately that he didn't really take the other side seriously. He didn't really think they were going to sue him. So he just put it in his desk drawer. And that was a couple weeks ago. He called back the other day and well, sure enough, they filed a lawsuit against him. So I think doing nothing is a terrible idea. Because if someone sends you a cease and desist letter and says you either stop or we're going to sue you, and you don't respond, that signals weakness. That is a show of weakness. There is blood in the water, and I think there's a good chance they're going to file a lawsuit. They're going to basically assume you didn't do anything in response. You didn't reach out to them. You didn't have a letter written to them. You didn't do anything because you're afraid of dealing with it. You're going to pretend it doesn't exist. That's a sign of weakness. There's blood in the water. They're probably going to sue you. So that's a terrible idea. And 99.9% of the time, I would take that option off the table. I would treat that as if it doesn't even exist. So now we're into the real options, which are 2 and 3. You can either send a response or you can sue. Let's talk about sending a response. We do a great deal of this. In fact, I started my own practice a little over 2 years ago. Prior to this, I worked for a prominent New York litigation firm, and about maybe 2.5 years ago, I started my own shop. Since then, since going out on my own, I have probably resolved over 200, maybe 250 non-compete disputes out of court. And what do I mean by this? Well, I've resolved these disputes through reviewing a cease and desist letter, reviewing a non-compete agreement, and then sending a response rebutting the arguments and allegations that the other side has raised. So if you get a cease and desist letter and you hire us to write a response, we're going to review that letter, we're going to go through the case law, we're going to determine what our strongest position is, and the goal in sending a response is to point out why the other side is wrong, why there has been no violation, why what you're doing complies with the agreement, why the agreement is unenforceable under Florida law. At this point in my practice, I have done this in so many different scenarios and in so many different industries. I've had disputes that revolved around customers. I've had disputes that revolved around confidential information. I've had disputes that revolved around suppliers. I've had disputes that revolved around specific geographic territories. With respect to industries, I have had disputes that involve doctors. I've had dozens of doctors, from neurosurgeons, pediatric cardiologists, neonatologists, orthopedics, podiatrists. I've had doctors and doctors and doctors. I've had numerous people in the sort of broader medical industry. I've had numerous people in medical gas. I've had numerous people in medical equipment sales and service. I've had numerous people in pharmaceuticals, in medical supplies, in durable medical equipment. I've had numerous people in technology, software developers, coders, hackers. I've had numerous people in various sales capacities. I've had numerous people in the finance industry, people who own insurance agencies, wealth managers. I mean, the list just goes on and on and on. So at this point, having done this dozens and dozens and dozens of times, more than 200 times, I have a very good handle on certain industry-specific issues. I know in a given industry what the issues are likely to be, what the claims are likely to be, what the allegations are likely to be, and the best way to fight back against those allegations. So from my experience, when people get a cease and desist letter, the single most valuable and cost-effective option for addressing this is to hire our firm to step in and write an aggressive response to the other side. In the vast majority of instances where we do this, where we send a response, the case simply goes away. 9 times out of 10, perhaps more than that. In fact, I'd probably say 9.5 times out of 10, I never hear from the other side again. In some instances, they will want to sort of go back and forth a little bit. I'll send them a response. They'll send me something back saying, you're full of it, blah, 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 we're still going to sue you. And in most instances, my response is, okay, go ahead, bring it. And they rarely do. They rarely do. I had one instance in which we sent a response to a cease and desist letter where the client was steadfast in saying he never signed a non-compete agreement. They had a non-compete agreement which contained his purported signature, but he insisted he never signed it. And in fact, he produced numerous other documents that contained his signature, ranging from his driver's license to, copy of his mortgage and numerous other documents that contained his signature, some of which were notarized. So he signed them in front of a notary. And his real signature bore no resemblance whatsoever to the signature that appeared above his name on his non-compete agreement. So I deduced that they had, in fact, forged his signature on a non-compete agreement. So I sent the other side a response to their cease and desist letter saying, number one, this thing is unenforceable for the following reasons. Oh, and by the way, my guy never signed it. You forged his signature, so you better piss off. They came back and they had the audacity to say that, oh, you're making outrageous accusations. You're alleging we forged blah, blah, blah. My clients would never do that. How dare you? So I proffered, some evidence of his actual signature, and I told him to go away. And they did, because they knew I had him. So 9.5 times out of 10, that's the sort of situation. We send a response, it goes away. Maybe there's a little back and forth, and it goes away. Even if we send a response and they ultimately sue, usually there is a good deal of time in between our sending a response and them suing. I've had cases where we sent a response and there was some back and forth and they still wanted to hem and haw about it, and eventually they sued, but they didn't sue for a year or more. Now, what's that do? What's the operation of that? Well, it's very important, because in many of these cases, the plaintiff is not only seeking to get money damages, they are seeking an injunction. And they're doing this for 2 reasons. Sure, they're doing it to prevent you from actually using any confidential information or from actually having contact with their substantial customers, if they have substantial customer relationships, but they're also doing it, for something that's beyond, the simple legal purpose. They're doing it to inflict harm on you in the market. They're doing it to run up your costs, to prevent you from making money, and possibly to get back any revenue they were losing from those customers. But more than just getting back the revenue, they're doing it to inflict harm. They're doing it to raise their rivals' costs. That's an old antitrust theory, RRC, raising rivals' costs. So if they sue you and a year's gone by, or 14 months or a year and a half, the reason why that's so important is because that sort of delay militates against granting a preliminary injunction. One of the bedrock principles of preliminary injunctions is you are not entitled to a preliminary injunction unless you can show that absent an injunction, you will suffer irreparable harm. Now, it stands to reason that if some folks felt they were going to be irreparably harmed by you allegedly violating a non-compete agreement, it stands to reason that they would have immediately gone into court and asked for an injunction. But in many instances, if there's a delay, And certainly if there's a year or a year and a half delay where they send you a cease and desist letter and they say, you're stealing our customers, you're violating your non-compete agreement, you're causing us damages, and we are going to sue you and we're going to seek an injunction. And then we send a response and a year goes by and they don't do anything. Maybe they come back and forth a little bit and say, you can settle with us, blah, blah, blah. You can buy out your non-compete agreement, but they don't go into court. And they wait a year, they wait a year and a half, and then they go into court. And they say, we need an injunction or else we're going to be irreparably harmed. Well, that just doesn't fly. It doesn't fly. Because it's basically proof that there's no irreparable harm, that you don't need an injunction, and that you can just wait your good old time and have your case play out on a normal track. And if you have any damages, you can prove those damages. And if you win, you can recover those damages at the end of the day. So sending a response is a fantastic strategy for a number of reasons. In many instances, it simply disposes of the dispute entirely. In other instances, it delays litigation, thereby preventing the other party from having a legitimate claim for a preliminary injunction. So probably 90% of the time, I recommend people hire us to write an aggressive response to a cease and desist letter. That leaves maybe 10% of instances where I think there's a viable strategy for us to sue first. What do I mean by that? Well, you can sue first for any number of different reasons. You can sue first for a declaratory judgment. That's the most common situation where we sue first. We're seeking a declaration from the court saying that the non-compete agreement is unenforceable for any number of different reasons. Usually, the declaratory judgment strategy is only viable where there is some clear-cut basis on which the non-compete agreement would be unenforceable. And I'll give you a very good example. If the non-compete agreement was for 2 years, but it's already been 2.5 years and the other side is still blowing smoke, then you can sue for a declaratory judgment. If the non-compete agreement was written for something absurd like 7 years and it's already been 3.5, you may be able to sue for a declaratory judgment and have the court declare that a reasonable amount of time is run and the non-compete agreement is not enforceable to the full 7 years as written. You can sue for a declaratory judgment with respect to geography, where if the non-compete prohibits someone from working within a certain radius and they're outside of the radius, but there's a dispute over how that radius is calculated, whether it's based off of sort of a central office, all of the offices, where the person worked, you can sue in that instance and have the court declare the actual geographic scope of the agreement. So there are a number of instances in which you can file a DEC action. Why is that important? Why is that helpful? Why would you want to do that? Well, first, filing a DEC action, suing somebody first, is great from a standpoint of signaling. It basically signals to the other side, look, you shouldn't have messed with us. We're geared up for this, and we're going to fight you, and we're going to fight you hard. That's always a great signal to send from a marketplace standpoint, from a sort of policing standpoint. It's good to send that sort of signal to rivals, particularly rivals with whom you have some, connection in the form of a non-compete situation. That's number one, just the value in the marketplace of sort of establishing yourself and checking other people's conduct. That's number one. Number two, you often file a DEC action because you want to get the case into a certain forum. In most instances, when I file a DEC action, I try and find some way to get the case into federal court. I will do whatever possible. I will push the envelope to the absolute limit to get the case in federal court as opposed to state court. And I say this for a variety of reasons. There are some significant differences in terms of the applicable standard for issuance of a preliminary injunction in federal court versus state court. It's harder to get an injunction in federal court in Florida than it is to get an injunction in state court. So for that reason alone, I always try to force these cases into federal court if at all possible. You can also sue first, not only for declaratory judgment, But you can also sue first for affirmative claims, such as if the other side breached an agreement, if they owe you money, if they committed fraud, if there's something else there that you can add into the mix that you can sue them for, that can also be very helpful. Because then you can add in a declaratory judgment action, and now you not only have a deck action, you not only have sort of a defensive case where you're going to be defending the non-compete, you also have an affirmative claim for relief, which gives the other side some more exposure. So that's why you would sue first, but you'd only do that when you're in a particularly strong position. It's been a long talk today, but hopefully it's been a helpful one, and hopefully this has given you some insight and is going to help you in terms of where you decide to go from here. But if you get a cease and desist letter, remember your options. 1, do nothing. That's a bad idea. The only real options are 2 and 3. That's hire an attorney who does this sort of work, who has experience in non-compete and trade secret litigation. Hire them to write a response. Or option 3, sue first for a declaratory judgment or other affirmative relief, but only if you have a particularly strong case. Jonathan Pollard, non-compete and trade secret attorney in downtown Fort Lauderdale, Florida. If you have a question or a concern about a non-compete or trade secret issue, please feel free to call my office. I'd be happy to talk. Thanks for watching. Have a good day.